Good afternoon. It's the appointed time. We have a quorum. Let me first invite government officials to join us.
我宣布海上安全酒精及藥物條例草案第三次嘅
I call to order the third meeting of the Bills Committee on Marine Safety, Alcohol and Drugs Bill.
繼續咧就會進行逐條審議。
We will carry on with the clause-by-clause examination of the bill, but before that, I will give time to the administration to fully respond to issues raised in the last meeting. Afterwards, we will continue with the clause-by-clause scrutiny. Deputy Secretary, over to you. Thank you, Chairman. Since the meeting on the 18th of March, we have provided a written response to issues raised. Thank you for giving me the time to make a response. First, on the definition of junk. It provides a description of junk under the definition of vessel. We referred to CAP 313, Shipping and Port Control Ordinance, as well as CAP 548, the Merchant Shipping Local Vessels Ordinance. After careful examination, we find that Point A under definition of junk overlaps with Limb C. Therefore, when we drafted the bill, we updated the definition of junk. As you can see, we made a technical amendment on the connective or and. And since the current definition of junk under CAP 313 and CAP 548 still is in effect, we find that, however, there is no urgency or pressing need to amend the relevant definition under the two ordinances. On the definition of vessel, as mentioned, this bill is to regulate marine safety. Vessels now can move freely in Hong Kong waters. According to the existing ordinances, a vessel includes any other description of vessel that is not used or not constructed or adapted for use in navigation. To avoid any loopholes, we want to cover a broader definition for vessel to cover all vessels in the Hong Kong waters, especially those that appear at different times, and this is in line with the practices on the mainland as well as other jurisdictions. On the definition of authorized officer, according to CAP 232, the Police Force Ordinance, the term police officer is clearly defined. Therefore, we think that the definition of sergeant in the bill is already sufficiently clear, and it serves the purpose of providing definitions, which is to make a legislation easier to read and understand. On the definition of designated duties, as mentioned last time, protection of marine environment includes avoiding oil leakage, discharge of marine refuse, chemicals, etc. to the sea. If these materials are discharged directly to the sea, it would cause serious damage to the marine environment and even endanger the safety of other marine users and vessels. It may also lead to explosions or fires. To ensure marine safety, we think it's necessary to include the duty of protection of the marine environment in the bill. Chairman, we're happy to take any questions from members. Thank you. Any views from members? All right, I will invite members to press the button. Mr. Lam Chun Sing for the first round. Thank you, Chairman. In the previous meeting, we discussed the issue about beaches. The administration proposed a number of solutions. It was said that there are lots of collaborations between the LCSD and the Marine Department. I wonder if the administration has been in talks with LCSD since the last meeting about this. If LCSD imposes stringent regulations, there can be a lot of objects that can be considered as vessels in the sea. You mentioned last time that most of the buoyant objects, including boat-like objects, they may not be covered in the bill in designated beaches. Can the administration tell us that offenses in beaches are excluded from the bill? Say there may be swimmers that got into the sea because of big waves, and this may be an exemption. I just want to make sure that people on beaches, they would not fall foul of the legislation. Of course, those who have consumed alcohol, whether they are suitable to swim in the sea, that would be another story. I asked about unmanned vessels last time. Well, we haven't seen a lot of unmanned vessels yet, given the existing technology. It was mentioned last time that someone may operate an unmanned vessel remotely, and these kind of vessels are covered in the bill. That means the person who operates an unmanned vessel may breach this bill. For small boats that would not endanger other marine users, you're not including them in the bill, but for big boat or vessel models that are motorized, would those be included in the bill? For unmanned vessels or boats, if the operators of such vessels are regulated by the bill, then you have to make it clear in your provisions. These kind of vessels may become more common in the future as technology continues to advance. I'm not exactly sure if this bill would concern these kinds of operators. Anyway, you'll have to make it clear. Thank you.
第一呢，就係我哋進入逐字。
We were about to start clause-by-clause scrutiny, but then I allow your questions for the administration. There's the word operate. There's a definition of the word operate, that is to determine, to exercise control over, or to be in charge of the course or direction of the vessel or the means of propulsion of the vessel. Administration. Thank you, Chairman. I'd like to take some of the questions, and I will defer to Mr. Wang, Director of Marine, to answer the remaining questions. Regarding beaches, we already addressed that issue in last meeting. Beaches are connected to the water bodies in Hong Kong. As Mr. Lam mentioned, some cases are more special. For some cases, the person is away from the beach and is under the influence and then enters the beach area, then that person is subject to the law or the legislation. I'd like to add something to Mr. Lam's question. For swimming rings, buoyant objects, or for swimmers who have taken drugs or have drunken after the enactment of the bill, will they be caught by law enforcement officers? I'd like to make it clear that the policy objective of the bill does not target people using floating beds or swimming rings after taking drugs or after drinking. We don't target this type of people. Instead, we target people who operate vessels that are underway or perform designated duties on a vessel that is underway after taking drugs or after drinking. That's the policy objective of this bill. Buoyancy objects or swimming rings aim to help swimmers swim. In general, the person is not operating any vessel. After the enactment of the bill, to decide whether someone breaches ordinances under the bill, the administration does not focus on whether the object is a vessel. We also need to consider whether the person is operating vessel underway, or whether the person is performing designated duties on a vessel that is underway. So when someone is using buoyant object, one will not be considered to be determining to exercise control over or to be in charge of the course or direction of the vessel or the means of propulsion of the vessel, or to pilot the vessel under the pilotage ordinance. Simply put, after taking drugs or after drinking, using floating beds or swimming rings normally, one will not be caught. After the enactment of the bill, we'd like to take this opportunity to make clear our stance. If we have the support of members like Mr. Lam, we'll discuss with the LCSD to see how we can step up public education and public publicity. That is to ensure swimmers or the public won't have any concerns or worries. I'd like to ask Mr. Wang, Director of Marine, to talk about model boats or unmanned vessels. Thank you, Chairman. Thank you, Mr. Lam, for your question. In the last Bills Committee meeting, we also touched upon the definition of vessels. It's subject to many different factors. We don't simply define something as a vessel when something takes the shape of a vessel. It depends on the structure, the purpose, the mode of operation, and the purpose of the operator. The mode of operation leads us to the point mentioned by Mr. Lam, that is motorboat. As far as I understand, there are unmanned vessels in operation nowadays. I'm talking about container ships or cargo ships from one port to another. It has freight capacity. It's not a small boat. For recreational boats, from the perspective of operation, it's recreational in nature. It is not used to determine, to exercise control over, or to be in charge of the course or direction of the vessel. It's smaller in size. When we take a look at the bill, the purpose is to regulate people performing certain duties on board vessels in the waters of Hong Kong. That is somebody who determines to exercise control over or to be in charge of the course of direction of the vessel. If a motorboat is only recreational by nature, it does not determine or exercise control over or to be in charge of the course or direction, say from A to B. Even if a motorboat can move a milk box, we don't consider that boat as a vessel either. if an unmanned vessel can convey goods while determining or exercising control over the course or direction, as we said in the last Bills Committee meeting, the definition of vessel is more than the shape of the object. We also need to take into account the construction and the purpose. So it depends on how the operator operates the object. Just now, you said as small as conveying a milk box, you won't consider it a vessel. What about one as large as conveying goods? The point is, what is the definition of large? How large is it? How small is it? Do you leave it to the magistrate? Well, we are not talking about certain tons of container or goods container. It's not about the operation of the vessel. It's not about the size of the vessel. It's about whether the size of the vessel or boat is such that the course or direction of the vessel can be determined or can be controlled. Simply put, if there are some existing unmanned container or goods vessels, in theory, the operator will be covered by the bill or by the ordinance. Actually, not after the enactment of the bill. In actual fact, you need to tell the industry that they need to pay close attention to this. Next, Mr. Yim Kong. Thank you, Chairman. Mr. Lam said what I wanted to say. I'd like to follow up, though. For drink boating, the penalty follows the penalty for drink driving, like in a motor vehicle. The definition of vessels do the ships need to be dynamically supported or need to be motorized? For motor vehicles on the ground, when there are accidents, say when bicycles crashed into each other, there are traffic accidents. Do you consider that as drink driving? For floating beds, swimming rings, I don't consider them motorized objects. Is it a must that you put them under the definition? That's all from me. Thank you, Mr. Yim, for your questions. We cover all vessels, whether motorized or not motorized. You are in the waters of Hong Kong. As long as you operate the vessels in the waters of Hong Kong, if you are under influence, you not only affect yourself, but you also affect other users of the waters of Hong Kong. So all vessels in Hong Kong need to be regulated as well. For vessels, we use a wide definition. This practice is in line with that in the UK, mainland, and Singapore. In New South Wales, Australia, there are also similar laws. There is exception in that overseas jurisdiction, but that is a rare occasion. Our practice is in line with the international practice. Just now, Mr. Yim mentioned bicycles. Actually, riding a bicycle under the influence of alcohol is subject to law. It's not the case that it's not subject to regulation. Next, Mr. Chen Siu-hong. Thank you, Chairman. Well, excuse me, I was a little bit late. I came from another meeting. That's fine. I have two questions. One, on the definition of vessels. We discussed it for many times. We have concerns over it. If we don't have a clear definition of vessels, members of the public will break the law inadvertently. They won't understand the definition of vessels either. Just now I heard from the administration, and I'd like to say, for non-motorized floating objects like floating boards, floating beds, and so on, are they also seen as motorized? But however, for swimming rings, nowadays they are not motorized. But what about the future? There might be motorized swimming rings in the future. You can't tell from the surface. If you don't include these swimming rings, will there be problems in the future? But I keep my mind open. Now that we don't know whether these will crop up in the future, I don't suggest writing it down right now. But what about the future? When we see such cropping up in the future, we may amend legislation. Moving on to my second point, regarding the definition of waters of Hong Kong and within Hong Kong, why don't we include the words within Hong Kong? Has the Deputy Secretary explained? Well, she didn't explain today, but she explained in last meeting. As I heard from the administration, within the waters of Hong Kong, that's what the legislation reads right now. That's KEP 313 and KEP 548. So, in a scenario when someone is under the influence of alcohol, when one operates a boat all the way onto the beach, when the boat is aground on the beach, which ordinance will you invoke to charge that person?
逐字審議。
We are examining the bill now. Let's begin from Clause 2 of the bill. Deputy Secretary, I've just read out our stance. If you don't mind, I'll read it out again. Our point of view is that the objective of the bill is not targeting those who use swimming rings or buoyant objects after consuming alcohol or drugs. This is not the purpose of the bill. Our goal is to regulate those operate a vessel underway within the waters of Hong Kong who have consumed alcohol and drugs. Swimming rings and buoyant objects alike are not normally considered as vessels. While we haven't excluded buoyant objects from the definition of vessels, upon passage of the bill, when we decide whether a person has committed an offense, we'll not only look at whether the vessel concerned falls within the definition of vessel under the bill, we will look at whether the person is operating the vessel concerned or performing any designated duties in the vessel. Therefore, we will not simply look at the vessel. We'll see whether the person is exercising control over determining or being in charge of the course or direction of the vessel, or exercising a function in connection with the navigation of the vessel, or piloting the vessel under the pilotage ordinance. This is our stance. As mentioned, within the waters of Hong Kong, well, those who are within the waters of Hong Kong will be regulated under the bill. For those that have committed drink boating or drug boating, even the relevant vessel concerned is stranded. The person involved will still be considered as having breached the law. Like Mr. Chen said, someone who has consumed alcohol and keeps running on the beach, and does that mean we won't be able to catch that person? We'll have to look at the evidence. We will see whether boat boating or drug boating was committed while the vessel was underway. Would you be able to provide a written submission of the position you have just read out? Perhaps our officers or staff can help print out or make copies of that document and distribute to members. Thank you. Now it's my turn. On unmanned vessels and boat models, well, I have questions about the operation of such vessels. For model boats, they have to be operated by someone, because the person that operates such vessel have to decide the course or direction of the vessel. However, do unmanned vessels fall within the definition of vessel or operate in the bill? I think it may fall under limb B of the definition of operate. I think the person that oversees such vessels or the system of such unmanned vessels should be held accountable. Am I understanding it correctly? That means, regardless of the sizes of such vessels, they will have to be operated by someone. Even for model boats, they may not be mechanically propelled, and there may be other ordinances that regulate such vessels. However, members of the general public may not know what kind of vessels are regulated by this bill. Can the administration tell us why model boats or model vessels are not regulated by this bill, regardless of the sizes? Let me put it this way. The entire bill, there's no mention whether vessels should be regulated by this bill based on the sizes of the vessels. Now we have to look at various factors when we decide whether a vessel falls within the definition of a vessel. We have to look at how a vessel is operated. For instance, so we won't just look at the size of the vessel to decide whether it is covered by the bill. The entire bill is not drafted to regulate certain vessels. Instead, it regulates the acts of persons operating vessels. So we mean to regulate the acts or actions of persons by this bill. Say it is not a model boat, it's just a small leisure boat. It may not endanger the safety of other people, but still, this kind of boat will have to be operated by someone. Would that be covered in the bill? It really depends on the structure, the function of the vessels, as well as the operators, the purpose of the person operating the vessels. Now, going back to the objective of this bill, the objective of this bill is to regulate persons who have consumed alcohol or drugs and proceed with operating vessels and performing certain duties on board vessels in the waters of Hong Kong, and we mean to impose restrictions on these persons through the bill. By operate, it means to determine, to exercise control over, or to be in charge of the course or direction of the vessel. And this has to do with the acts of a person. Yes, I'm referring to the acts of a person here as well. say, a motorized vessel or a model boat, and it is of a considerable size at sea. Say it can contain 2 sandbags, and someone that operates such vessel has taken alcohol or drugs. How do you view such a situation? I'm just saying that model boats may also fall under this bill. However, you'll have to look at the purpose of the person operating the vessel. Am I understanding this correctly? You'll have to look at the surrounding to decide how the person operates the vessels. Mr. Lee Chen-keung. Hold on, Mr. Lee. You've just joined us. The government has provided us with some response. I'm not going to be so strict for the first round, but we have already reached clause 2 of the bill. The definition of director, dentist, etc. have already been covered. I will be more strict with the time in the second round. I have a question about the response provided by the administration on the point about CAP 313 and 584. Apart from model boats, we have mentioned a number of times in the previous meetings about leisure facilities or leisure boats, including rubber boats, swimming rinks, inflatable objects, etc. In the previous meetings, it was mentioned that they may be considered as vessels. While the administration may choose not to enforce the law under certain circumstances, these are included in the provisions. Would it be the Marine Department or other government departments that make the final decision on whether to enforce the law, or is it the case that you will enforce the law anyway and you leave it to the court to make a judgment in the end? That's my first question. Second question about the acts of a person. How do you view people making insensible acts after consuming alcohol? Say someone who has consumed alcohol and is lying on the beach. Would the person breach the law? And how about a person who has consumed alcohol and tries to control a rubber boat by making arm movements to stay afloat at sea? Members, we've just got a written submission from the government on the issues about floating beds and other buoyant objects. Say I try to travel to Lamma Island on floating beds. How do you view such a situation? Administration, please. Thank you, Chairman. I believe members will have received the paragraph I've just read out. Please allow me to read out for the third time our position on this issue. I'd like to thank the Bills Committee for making such a constructive discussion on buoyant objects. We want to reiterate that this bill is to regulate marine safety, and we also mean to regulate those who operate vessels or perform designated duties on vessels in the waters of Hong Kong after consuming drugs or alcohol. On the question about whether swimming rings, floating beds, or other buoyant objects would be regulated or covered in the bill. After the passage of this bill, I would like to make it clear here that the objective of this bill is not to target those using swimming rings, floating beds, or other buoyant objects after consuming drugs or alcohol. Instead, we mean to impose restrictions on those who operate vessels or perform designated duties on vessels after consuming drugs or alcohol. Swimming rings, floating beds, and other buoyant objects alike are meant to help a swimmer stay afloat, and normally they are not regarded as vessels under operation. To decide whether someone breaches the law, the administration will not only just look at whether the vessel concerned falls within the definition of vessel under the bill. Instead, the administration will look at whether the person concerned is operating the vessel or performing designated duties on board of vessels at the material time. Therefore, swimmers that are using swimming rings or buoyant objects, they are not considered as controlling the direction or course of the vessel. To put it simply, those who use swimming rings or other buoyant objects after consuming drugs or alcohol would not be considered as having breached the law after the passage of the bill. We adopt a broad definition for vessels in the bill, and this is in line with the practice on the mainland, the UK, the US, and Singapore. For New South Wales in Australia, well, certain objects are excluded from the definition of vessels in their law, and this is exceptional, I believe. And overall speaking, the definition of vessels in the bill is in line with the international practice. The Transport and Logistics Bureau will reiterate the objective of the bill in this regard as the bill receives the resumption of second reading.
So there's a paper, a document, and the key word is normal operation or normal use. Mr. Lee Chen-kang, I have a question about two words. That is normal use. After one drinks, is he or she still operating or using normally? In some places, there are also definitions about vessels, including Hong Kong. Can you provide us with a table so that members of the public can also get a better idea? In news reports, there are some very novel ways of using a vessel or using a buoyant object. That is, if someone on purpose uses these buoyant objects for other purposes, that is not normal. Well, I see your point. You mean normal use by swimmers, for example. If someone throws a rubbish bin or a bathtub into the sea, and that is not normal, is that correct? For the table asked by Mr. Lee, we can provide members with a table detailing information about different overseas jurisdictions. We already have a document, and I can provide Mr. Lee with this document after the meeting. I hope we've wrapped up this point, unless you have very novel ideas. Let's return to clause-by-clause scrutiny. Well, one more member, Mr. Chen Siu-hong. Excuse me, Chairman, I'd like to seek clarifications. Just now, the Deputy Secretary has provided us with a written reply. The legislative intent is written in black and white. The Deputy Secretary also mentioned in the resumption of second reading debate, the Secretary will once again restate this stance. I'd like to ask our legal advisor, does it mean that in the future, when a judge needs to make any decision, all these can act as effective, valid legal basis? Yes, that is correct. Thank you, Mr. Chan, for your question. If a judge needs to know more about the legislative intent, government officials' representations or written reply in the in the resumption of second reading debate, that can also act as basis for judges to decide on. Well, actually, our meeting records, a verbatim record in Hansard. Mr. Lee Chen Kang, does it mean that law enforcement officers will not catch you? So they won't catch you randomly and send you to the court for the judge to adjudicate on your case. Is that correct? Well, in relation to law enforcement, I hope the administration will further clarify this point. I believe guidelines will be provided to the law enforcement officers. In Hong Kong, any law enforcement department, whether police officers or not, they need to ask the DOJ for advice to see whether the evidence adds up. In a normal use of swimming rings, if one does not paddle to Llama Island, well, they will also be rejected by the DOJ. Well, maybe the law enforcement officer identifies any other reason. We have internal guidelines as well as training. Well, right, if we catch any person just randomly or without basis, then the judge will also make a decision. They will also question our reasons. So, any special views on the meanings or the definitions of the words? If no, let's move on to clause number 3. Anything else to add by the administration as to clause 2? No, let's move on to clause 3. Clause 3 on the meaning of ordering that a person be disqualified. It regulates all vessels in Hong Kong, including ocean-going vessels. Comparing with Cap 347, it refers to disqualifying a person. Clause 3 is about issuing an order. If someone is under the influence of alcohol such that one cannot operate a vessel that is underway, the magistrate or judge will order that that person cannot operate the vessel in the waters of Hong Kong. If someone is under the influence of alcohol to the extent that one cannot perform any designated duty on board a vessel that is underway, the judge will order that the person is not allowed to perform any designated duty on board a vessel that is underway in the waters of Hong Kong. Regarding ocean-going vessels, OGV, the license are not issued by the Marine Department. We recommend the court can make the relevant orders that the person cannot operate ocean-going vessels. Any comments on this? So if one is caught for drink boating or drug boating, he or she will be requested to take a test, that is a drug test or alcohol test. Can that person still be operating a vessel? Because you need to wait until the court makes a judgment, orders a disqualification order, or disqualifying the relevant person. Yes, that is presumption of innocence. We can presume that the person has broken the law. That's a technical issue. Any question? Any comments? No. Let's move on to Clause 4. Clause 4. This ordinance applies to a vessel other than a warship in the waters of Hong Kong. In accordance with Article 63 and 64 of the Basic Law, this ordinance does not apply to warships, as warships are about the diplomatic affairs or foreign affairs of another jurisdiction. On to Part 2, Clause 5. A person must not operate a vessel that is underway while the person is under the influence of alcohol to such an extent as to be incapable of having proper control of the vessel. We've drawn reference from Section 39 of Cap 374. That is, when one drives while under the influence of alcohol, the penalty is exactly the same. Comparing with Cap 374, subsection 39 bracket 6, in the trial, the arrested person can be found not guilty for a charge, whereas found guilty of a charge 36 or 37. The reasons why we don't have these provisions in the bill is that we have already drawn reference from the ordinance and we have already introduced alternative charges, so we don't need to detail these charges once again. Members, no question? Legal advisor, there are two questions that we'd like to seek clarifications from the administrations. Bracket 5 and bracket 6. Bracket 6. If, as at the date on which the offense was committed by a person, at least 5 years have elapsed since the person's last conviction of a Part 2 offense, that person is regarded as having never previously been convicted of any Part 2 offense. In 374, the word "hor," that is may, is used, whereas in bracket 6, the word is used, that is in Chinese 在. That removes the discretion of the court. In bracket 5, the phrase special reasons, there's a special definition under Cap 374. It's been taken away from the bill, however. Actually, I wrote earlier to the administration, and I'd like to see clarifications or explanation from the administration. Well, in bracket 6, can the administration apply why the word 在 in English is used? In the written reply, we already explained this point. First of all, let me get to bracket 6. We changed the word 好 may to 在 in English is, that is to provide a clearer reference for the court. That is a blueprint for drink and drug boating to improve marine safety and to enhance public awareness about drink and drug boating. We've drawn reference from Cap 374, but we also need to make appropriate amendments in this bill. the marine environment is much larger than the road environment in Hong Kong. There are also many fewer accidents in the waters of Hong Kong comparing with the road in Hong Kong. We believe this already has enough deterrence. So we don't think we need to give the court any discretion when it comes to sentencing. Regarding the phrase special reasons, the provisions give discretion to judges and judicial officers to exercise discretion, but the definition in Cap 374 is quite general. It's not quite specific. So in the bill, we don't think we need to add a footnote. We can leave it to the court to interpret it. The court can also take into account any facts in relation to the person being charged. Mr. Yim? Thank you, Chairman. I'd like to refer to bracket 5. Well, I mean clause 5, brackets 2. A person must not perform any designated duty on board a vessel that is underway while the person is under the influence of alcohol to such an extent as to be incapable of performing the designated duty properly on board a vessel. Well, regarding the word incapable of performing, when someone is only tipsy, even if someone has already drunken a lot of alcohol, probably someone has a very high alcohol threshold. Do we need to change the word? Well, if someone has a very high alcohol threshold, someone may only get tipsy when someone consumes a certain level of alcohol. Do we need to change this word? Thank you, Mr. Yim.
第6條嗰度咧，其實就係
I believe clause 6 of this bill responds to the member's question. It says that if a person operates a vessel that is underway while the proportion of alcohol in the person's breath exceeds the prescribed limit, that would be an offense. Perhaps you can specify what the prescribed limit is under clause 6. Well, you may look at clause 5 and clause 6 in parallel. Under clause 6, there is mention that if the level of alcohol exceeds the prescribed limit, it would be an offense. For some people, they may not be drunk even after consuming a lot of alcohol, but still, the person may not be capable of operating a vessel, and that would fall under clause 5. Perhaps you should explain the meaning of incapable, that is, the level of alcohol exceeding the prescribed limit, and second, you may ask the drunken person or the person concerned to walk a straight line, and if he fails, then he is considered as incapable. Is that correct? Yes. So, Mr. Yim, incapable means such here. As to whether clause 5 and clause 6 needs to be revised, the administration can look into that. Mr. Chen Xiu-hong. I'd like to ask about clause 5, subclause 5. The administration's response mentions that it would leave it to the court to make a decision. Does the administration have any thought about special reasons as provided for under Cap 374? Or are you leaning towards leaving it to the court to exercise a discretion under this bill? Should special reasons be provided for in this bill as well? Are there any previous cases that you can share with us in which special reasons were cited by the court? Ms. Chen. There's mention of special reasons in other ordinances such as Cap 374 to allow the court to exercise discretion to give a more lenient sentence. In Cap 374, special reasons is interpreted in a specific way, and we decide as we drafted the bill to exclude special reasons in this bill. If we are to retain the term special reasons in this bill, it would not interfere or change the interpretation of such term. So we decide to preserve it. So you made reference to Cap 374 on keeping the term special reasons, but on the other hand, you are not keeping the same interpretation of the term in this bill. Would there be any problems if you adopt the same interpretation of the term special reasons in Cap 374 here? Deputy Secretary, let me invite Director of Marine Mr. Wong to share with you about this. Well, I'm not a judge. I'm just trying to explain this concept here. Mr. Chen understood it correctly. On what it means by special reasons, let me raise an example. This bill is not only governing those using local vessels. Ocean-going vessels would also be covered by this bill. Say a foreigner commits an act or offense under the bill, and according to immigration law, the person has to leave within 5 days. And the judge allows the foreigner to leave Hong Kong within 5 days, and the judge may impose a restriction that the foreigner will not be able to operate any vessels within the 5 days period. And the license held by the foreigner is not issued by the authorities in Hong Kong. The judge may, in this case, take into consideration the length of stay of the foreigner as the judge impose a sentence. I believe the judge would take into consideration the actual circumstances of the case. It's not like we can foresee all kinds of circumstances now. It's about disqualification here. I believe the court's decision would not have a very huge impact here. Well, if there are no further questions, let's move on to Clause 6. According to Clause 6, it's about operating vessel or performing designated duty while alcohol concentration exceeds limit. As long as there is proof that the person concerned while operating a vessel that is underway, the proportion of alcohol in the person's breath, blood, or urine exceeds the prescribed limit, it would be an offense. The different prescribed limits are in line with Section 39A of Cap 374. So this is comparable to other existing ordinances, I believe. So there is Clause 4, Subclause 5, and Subclause 6. Clause 7 provides for alternative offenses for person charged under Section 5 or 6, and this includes offenses in relation to Section 32 of Cap 548 and Section 72 of Cap 313. Could you repeat, please? Clause 7 provides for alternative offenses for person charged under Section 5 or 6. There's the offense of endangering other person's safety under Section 32 of Cap 548 and Section 72 of Cap 313. So this clause provides for alternative offenses. Clause 8, please. Clause 8 provides that an authorized officer may require any person to provide a specimen of breath for a screening breath test. And Clause 8, subclause 4, stipulates that an authorized officer must warn the person that a failure to provide it may render the person liable to prosecution. Subclause 5 provides that an authorized officer may arrest a person without a warrant. We've made reference to Section 39B, bracket 1 to 5, as well as Section 39, bracket B, bracket 9. Subclause 5 here says an authorized officer may arrest a person without a warrant. Well, some people, when they take the screening breath test, they are not very cooperative. It's not the case that those people refuse to provide a specimen of breath. They're just not cooperative. How would you deal with such situations? Enforcement Department, please. Well, we will adopt the same practice as stipulated under Cap 374. There are some breathing devices. If the person does not cooperate, then the test will not be able to be conducted. Under such cases, we will consider that the person fails to provide a specimen of breath. Then you leave it to the court to make a judgment, right? Let me add something. Clause 9, subclause 2 states under what circumstances a screening breath test would be considered as having failed. And this is related to Clause 8. Yes, Mr. Chen Xiu-hong. We're now on Clause 8. There's a question raised by the legal advisor on Clause 8, and I'd like the administration to make a clarification here. Understand that the administration has made reference to Cap 374 on how an authorized officer may decide that the level of alcohol in the person's body may likely exceed the prescribed limit. I believe the administration has already provided a written response on this. Well, the question asked by the legal advisor is about a blood test. It's not about the breathing test. I believe Mr. Chen Xiu-hong is asking why under this particular bill we're only asking the person concerned to provide one specimen. This is because the instrument procured by the Marine Department has been upgraded. So the person concerned will only have to provide one breath specimen for a screening test to complete the preliminary test. And a statement will be printed based on the result of the screening test as an evidence. So only one breath specimen will be needed because of advanced technology. Well, this is because with the new devices, you'll be able to come up with more accurate test results. That's why you're only asking for one breath specimen. But under Cap 374, The person concerned will be required to provide 2 specimens of breath for alcohol analysis. Why do you not follow Cap 374 and state that the person will have to provide 2 specimens of breath? Well, let me clarify. It's because we have invited university professors to look at the test results generated by the devices. And with the new model of the screening devices, we only require the person concerned to provide 1 breath specimen only. As to whether the relevant provisions in Cap 374 will have to be amended or revised, I believe I won't be able to give you an answer here. I think it will leave it to the relevant departments to make a decision. Clause 9. It is stated here that a person who, without reasonable excuse, fails to provide a specimen of breath for a screening breath test when required to do so under Section 8 commits an offense. We've made reference to Section 39, bracket B6, as well as Section 39, bracket B, bracket 8, and bracket 10. This is a bit vague. I mean, subclause 2b. It says here that if the specimen is not provided in a way to enable the objective of the test to be satisfactorily achieved.
測試部門
Which official will take the question? Technical department? Testing department? Well, in our breathalyzer, if there is not enough breath, it won't show a reading. So it means whether someone is providing a sample correctly. Well, you do need to maintain your breathalyzers well. Well, you do need to maintain them well. Any record of failure? Any defect? Well, you need to maintain them well. Mr. Lee Chen-kung. Well, pardon me, I'd like to ask about breathalyzer. Let's go back to breathalyzer. On speed detection, there may be buffers in relation to the breathalyzers. Any flexibility, any margins. How do you define the cutting point or the borderline? Director? There's no plus or minus in the buffer zone. But if I remember correctly, the breathalyzers need to be calibrated every year. That is annual calibration. That is correct. Some may be as accurate as 99.99%. What about this one? What about your breathalyzers? How accurate are they? We are looking for the information. We'll get back to you in a moment. Let's give them a moment. Well, maybe we can carry on first. We're still looking for it. Let's carry on. When you're ready, you can tell us. Mr. Lee, any more comments? No, we can continue. Move on to clause 10. providing specimen for alcohol analysis or laboratory test. Is applicable to people who have not passed the test or those who cannot provide a test with a reasonable excuse. Depending on the situation, the authorized officer may require the person to provide a specimen of blood or urine under subsection 1. In a strong reference from section 374 bracket C brackets 1, 2, 6 to 9, 14 and 18. Members, Mr. Lam, followed by Ms. Doreen Kong. Thank you, Chairman. Clause 10, subclause 7. If a person is required to provide a specimen of urine under this section, the person must A. provide a first sample of urine for discard, and B. provide a second sample of urine within 1 hour of the requirement as his specimen. With reference to the Road Traffic Ordinance RTO, for drink driving on the road, one needs to provide 2 samples of urine within 1 hour. I mean, within 1 hour after the first sample, one has to provide the second sample. But in the RTO, it does not state that one has to provide a first sample of urine for discard. Well, is the procedure actually the same, or is it not the same? Deputy Secretary, or which official will take the question? Principal Assistant Secretary. We drew reference from section C 14 of CAPS 374. We have commissioned a toxicologist to make this decision. Experts said that to discard the first sample of urine because in the urine sample, probably the urine before the consumption of alcohol is mixed in the urine sample. And this practice is in line with practice in other jurisdictions. We have already consulted the government laboratory. This method is considered viable. I understand the second sample is more important, but in the RTO, it does not specify that one has to provide a first sample of urine for discard. If that's what you mean, can we say that the procedures are actually the same? That is between the practice in terms of marine safety and the road traffic ordinance, they are identical. Can we put it this way? For drink driving and drug driving in CAP 374, that was actually the first time ever. However, when we reviewed the situation and before we draft this bill, we consulted experts at university. So the more accurate we can put it, the better. Otherwise, we don't provide for the use of the first sample of urine. That may give rise to confusion. That is whether providing sample of urine in the after 1 hour would suffice. This would be confusing. I think the current presentation is good enough. Thank you, Chairman. Ms. Doreen Kong, thank you, Chairman. I'd like the administration to tell me the correlation between subclause 2 and 3. Under what circumstances when a person needs to take this test? Regarding the screening breath test, one needs to take this test when the proportion of alcohol in the person's breath is likely to exceed the prescribed limit, or if a person who fails to provide a specimen of breath for a screening breath test with reasonable excuse. Subclause 3 is quite special. The authorized officer may may require the person to provide a specimen of blood or urine under subsection 1 only if the following conditions. So can you set out very clearly under what circumstances when a person would be required to provide a specimen of blood or urine? The correlation between subsections 2 and 3, subclauses 2 and 3 is not very clear. I'll ask Mr. Chuck, General Manager of Operations, to take this question. Thank you, Chairman. Thank you, Mr. Rincon, for your question. Under what circumstances would a person be required to provide a sample of blood or urine? We need to take into account the actual situation. If the person in question has a wound in his or her oral cavity, or when he or she fails to provide a specimen of breath, we may require the person to provide a specimen of blood or urine to prove whether that person has breached the relevant offense. So we will decide on the appropriate method taking into account the actual situation. So you accord priority to giving breath samples, is that correct? Well, the reason why I asked this question is that it may be easier to take this test on the road. But after reading subclause 3, like Chairman said, we definitely prioritize breath tests. Can someone insist on giving specimen of breath instead of blood or alcohol? It seems to me that that person in question does not have a choice. He or she is not at liberty to choose. Is actually the authorized officer who can make the decision. Including subclause A, the officer has reasonable cause to believe that for medical reasons a specimen of breath cannot be provided or should not be required. It boggles my mind actually. Or subclause B, at the time the requirement is made, an approved breath analyzing instrument is not available on the vessel concerned or at the designated test center, the police station, or the hospital where the requirement is made, or it is not practicable to use an approved breath analyzing instrument for any other reason. What do you mean by not practicable? Is it easy to carry the breathalyzer around with the authorized officer? It may be quite cumbersome or troublesome to provide a sample of blood or urine. Can you give us more information? Well, please explain in conjunction with clause number 9. That is the accuracy of the breath sample or the breathalyzer. Regarding the accuracy of the breathalyzer, it's plus or minus 5%. Regarding the instrument, it has gone through a series of tests, a total of 7. It passes in all 7 tests. It's Mr. Rincong's time. Maybe you can answer Mr. Rincong's question first. That is when to use blood, breath, or urine. And you can give us an answer in conjunction with, together with clause number 9. Thank you, Mr. Rincon, for your question. Under what circumstances will specimens of blood, urine, or breath be used? We need to take into account the actual situation. Using a handheld device is more convenient for our officers. As I said, if someone on medical grounds has a wound in the oral cavity or in the respiratory tract, when we are satisfied with the reason, we will conduct the test in another manner. So we will factor in the actual situation. We will conduct the test on the spot at the designated test center, the police station, or the hospital. Do you mean that not necessarily in the hospital? Well, if a screening breath test can be taken on the spot, definitely it will be conducted on the spot. For urine or blood, what about these two samples? Well, for blood samples, the test will be conducted in the hospital by healthcare workers, by medical workers. For urine, we have two vessels that are dedicated to this type of offenses. There are two toilets where these samples will be collected. Other water will not be mixed, so there's no contamination. We have a specially designed toilet to collect this kind of samples. Well, the waters of Hong Kong are expensive. Can you tell us how long it will take for this vessel to reach the vessel in question? With reference to the express report, alcohol won't go away after 8 hours. For drugs, they may stay in your body for as long as 24 hours. Mr. Rincon, you can carry on with your questions. Clause 10, 3B2. Romanian character 2.
Analyzing instrument for any other reason. 如果我睇返呢，即係話咩？
Can we not find it in Cap 374? That is not practicable to use an approved breath analyzing instrument for any other reason. With reference to Cap 374, Section 39C. Well, how do you interpret this? How do you explain this? Why do you need to add Romanian character 2 when it comes to marine safety bill? You don't have this in the road traffic ordinance. Thank you.
There are two scenarios. For instance, a person cannot use the breathalyzer, or for instance, the person suffers from oral ulcer and is not able to use the screening breath devices. There are other scenarios. For instance, the breathalyzer has been dropped on the floor. Well, there are always accidents like this, and if the breathalyzer is not reliable anymore, you may send the person to the hospital for another test. Section 39C, bracket 2, Roman numeral, or a small letter B of Cap 374, there is similar wording. It says that it is not practicable to use an analyzing instrument for any other reason. Any other questions? No, thank you. Mr. Lee Chen-keung, you have follow-up actions about the accuracy of the instrument, right? Well, the accuracy is 5% according to the administration. Well, there may be a chance that the person concerned may appeal with the 5% margin. According to Clause 8, we're going to ask for one specimen, and according to Clause 10, we will use the same device of the same model to conduct another test to cross-check the results. But you mentioned just now that you will rely on one specimen to institute a prosecution, or well, it is not to convict the person, it is just a threshold. Well, we have yet to reach Clause 15. If you look at Clause 15, subclause 3, if there is a difference between two specimens, we will use the one with a smaller proportion of alcohol. So the person subject to the test would be protected in this sense. So we will ask for two specimens. And we will compare the results of the two tests, and if there is a difference between the two tests, we will use the specimen with a smaller or lower proportion of alcohol. I'd like to ask about clause 10, subclause 7. It says here that the person must provide a first sample of urine for discard. Would you use another word instead of discard here? For instance, provide a first sample of urine for reference? You mentioned that you will send the person concerned to a room to get the specimen. Well, in actual practice, we're not actually going to discard the first sample of urine. We're not going to flush it away. But I believe if we draft it this way, we do have the right to discard the first sample. Well, I believe this has to do with the accuracy of your test. I think the word discard here sounds a little bit off. Well, this gives the impression to people that the first sample of urine will not be used because it will be discarded. I think that is the reason why the administration drafted it this way, because it means that the first sample of urine will have to be received to prove that the urine does not come from the remaining urine in the bladder the night before. That's why a second sample will be asked for. So that's why the administration has to make it clear that it will collect the first sample. Right, your point is whether it can be phrased in a better way. Can you use another word instead of discard here? If I may make a bold inference or speculation, from our perspective, we think it is safer to use the word discard. We won't be held accountable, or there won't be any liabilities if we discard the first sample. Well, the Chinese version is not drafted in a very proper way, I think. Can you use hei zi, for instance, instead of pao hei in the Chinese version? It sounds like it's going to be abandoned or thrown away. We're not going to dump the first sample into the sea. Well, if members do not have better suggestions, well, what about diu hei? Which means to dispose of in English. Well, it could be better than discard. Well, it is 6 p.m. now, and we have yet to reach 1/3 of the bill. I think we need to speed up. I hope that we can complete the clause-by-clause scrutiny in the next meeting. I would like to extend the meeting today so that we can cover more clauses. Yes, clause 11 is about asking for the person concerned consent. Normally, the specimen must be taken from the person by a medical practitioner with the person's consent. If the person concerned because of medical reasons cannot take the test, for instance, if the person becomes unconscious after consuming alcohol or does not give consent to receiving a blood test, then the medical practitioner must not take the blood samples. And this is with reference to Section 39C, bracket 10 to 11E of Cap 374. Mr. Chen Xiu-hong. I've referred to Cap 374. Can the administration explain to us about this. The whole clause is about how the situation will be dealt with if the person concerned does not give consent to providing blood specimen. Subclause 6 states that a specimen of blood taken under subsection 4 may be subjected to a lab test only if the person from whom it was taken has been informed or has given the consent. I don't really understand the logic. If the person does not agree to providing a blood specimen, why would the person agree to having the specimen sent to a lab? Well, according to the law, anyone who fails to provide a specimen commits an offense. As mentioned, it would be the easiest if we can collect the breath sample or specimen from the person concerned. Then there would be no need for us to collect a blood sample or urine sample. If a breath test is not feasible, then on the patrol boat, the authorized officer would ask for blood samples or urine samples. If someone is so drunk that he becomes unconscious, there would be no way for him to give a consent to provide a specimen. But as time passes, the level of alcohol in his body would drop. So this clause provides for circumstances under which medical practitioners may take blood samples from the person concerned for test. Say someone deliberately refuses to provide a blood specimen, then of course this would be an offense. However, if under the influence of drug or alcohol the person could not whatsoever give consent, then the authorized officer according to this clause may request a medical practitioner to take a specimen of blood from a person without the person's consent, because there is no way for the person to give a response. Well, the blood sample collected will be sent for test. Subclause 6b and c state that the person would be asked whether he would agree to having the sample sent to a lab for testing. Is that right? So what about the person concerned says he is unconscious and he has no idea whether a blood sample has been taken from him? How about if the person suspects whether the blood sample you got is actually from his own body? Well, according to Clause 11, we will tell the person or notify the person after he regains consciousness that a blood sample has been taken from him. And if this person refuses to have the blood sample sent to a lab for test, then it would be an offense. So you're giving the person a chance to make a defense. Well, what if the person questions whether the blood sample is actually from him? Well, medical practitioners have to abide by professional codes of conduct, and you have to have the medical practitioner to confirm that the blood sample is from that particular person. And without reasonable excuse, that person will have to give consent to having the blood sample sent to a lab. Is that right? If that person refuses, it would be an offense. Correct. If you tell the person the blood sample is from him, and if that person insists that he doesn't want the sample to be sent to the lab, then it would be an offense. Mr. Yim Kong. I understand Clause 11, Subclause 1. However, would you consider adding a sentence here stating that if necessary, you may ask medical practitioners from the nearest hospital or clinic, for instance, to take the blood sample? Well, when there is a marine traffic accident, if someone has to take the blood test, it may take 3 to 4 hours for you to send the person to a hospital for the blood test. If there is a hospital nearby, it may only take 1 hour. If the traveling time is too long, it may affect the result of the lab test. So I suggest that you add one sentence here that if necessary, you can ask a medical practitioner nearby to take the blood sample. Administration. Well, the medical practitioner that you designate may be from, say, the Hong Kong island, and it may take time for them to travel to the scene. Perhaps the administration can brief us on the actual procedure.
係處長。
Yes, Director. I'll try to explain. I thank Mr. Yim for the question. Clause 11, Subclause 5 states that the blood specimen taken may only be taken to a designated, can only be taken at a designated test center or a police station or a hospital. Say, doctor is on duty and the authorized officer may ask the doctor to help take a blood sample. So we are not going to designate a particular doctor to help take blood samples for us. That's not what it means here.
The scope is already very wide, actually. Let me respond to Mr. Yim's question, the scenario. Member is right. Usually these happen on the sea. If the suspect is sent to the shore, we'll send him or her to the closest clinic for these tests. We won't send the person in question to somewhere that are so far away that it takes 2 to 3 hours. Can the administration tell us the designated test center, what does it mean? Hospital, in theory, any hospital would do. Is that correct? Yes, that is correct. So one can choose the closest hospital. That's right. It's unreasonable and impossible to choose a hospital that takes 2 to 3 hours of driving. So do you mean adding a sentence, can choose the closest or what? If you add the closest, probably you need to define the closest. What does it mean by the closest or close to? I mean, if necessary, if it is really far away, you can add the closest one. You don't need to prescribe it. After all, I mean, the administration can give us a reply next time. They may be alternative to one another. Next, Ms. Doreen Kong. Thank you, Chairman. Under Cap 374, in the case of no consent, it's Section 11A. Section 39, subsection 11A. Is that correct? Capital letter A. Can you tell us your main question? Actually, clause 11 is not copied directly from Cap 374. I do agree we need to draw reference from Cap 374, but Cap 374 is quite complicated. When officials convince us to follow the method used in Cap 374, we find Cap 374 quite complicated. I'd also like to ask, in subsection 5, the specimen can be taken or may be taken on the vessel concerned. Is that possible? Definitely this is not from Cap 374. Cap 374 said that the sample could be taken in the test center, hospital, or police station. Right here, it says on the vessel concerned. Is that actually viable? Can you do so? Let me take the question about whether we can do it on the vessel. Usually we take the test in the hospital. If need be, perhaps we can arrange for a doctor or a qualified nurse to conduct a blood test on the vessel. But usually we conduct the test in the hospital. I'm a little bit worried, Chairman. If someone is unconscious, one cannot give consent. In the ordinance, I'm quite worried if it is written that a specimen of blood may be taken on the vessel concerned. Honestly, if someone passes out, probably he or she has drunken, or there may be other reasons. Well, you may say that the nurse or nurses are also qualified, but there is no other equipment to check the pulse of the person. It might be quite dangerous. You can check the heart rhythm of the person, whereas Cap 374 is different. One can be rushed to the hospital much faster. Well, if a specimen of blood may be taken on the vessel concerned, it may not be protective enough for members of the public. Contextually, it is related to subsection 4. If the medical practitioner to whom a request is made under subsection 3 considers it appropriate, it means it is a medical practitioner who conducts the test instead of anyone else. Well, the administration, can you let us know the definition of the vessel concerned? Do you specify any vessel, or do you mean the vessel in question? Can you explain to Ms. Doreen Kong? Well, the medical practitioner needs to consider it appropriate before a test can be conducted. The test can be conducted at a designated test center, a police station, or a hospital. Definitely, it is a medical practitioner who conducts the test. but then the venue can take place at a designated test center, a police station, or a hospital. And it also it also includes the vessel. Well, if that person is found on the vessel concerned, yes, it is that very vessel in question. What about in a police boat? Well, in case of marine police, the test will be taken at a designated test center. In clause 2, there's a definition of designated test center. It means a place, vehicle, or vessel designated to be a test center under section 47 brackets 1. Mr. Rincon, you can continue. Well, no more questions, so a medical practitioner can make a decision. I'll extend the meeting by 15 minutes. I hope we'll finish the meeting today 10 minutes past the original scheduled completion time. Clause 12, failure to provide specimen for or give consent to alcohol analysis or laboratory test. It draw reference from section 39 bracket C under cap 374. The penalties are exactly the same as those under cap 374. Clause 13 is about the protection for hospital patients. The medical practitioner in immediate charge of the person's case must be notified of the proposal to require such a specimen to be provided at the hospital. Withdrawn reference from section 39E under cap 374. Mr. Lam, as to the protection for hospital patients, I don't think these will be very common occurrences. One of the requirements is that the medical practitioner needs to state in writing the diagnosis justifying the objection. In accordance with the RTO, it's the same. I think you've drawn reference from the RTO. In the past, has the administration or have the law enforcement officers held conflicting views with the medical practitioner? If there is no dispute, I don't think there would be major problems. I just want to ask about the disputes over cap 374 in the past. That is in relation to the protection for hospital patients. Director of Marine. Which official will respond? I can take the question. I'm not sure whether there are any precedents in relation to cap 374. I can't answer Mr. Lam's question right now. I don't have figures at hand. I don't have information at hand. Well, it means that the requirement must not be made if a person becomes a hospital patient. Is that correct? That is, you need to get all the things done, like the collection of evidence before a person becomes a hospital patient. It's subject to the objection of a medical practitioner. From the perspective of medical needs, let me use the word suspect. If a suspect is not considered fit to take any test in general, We don't dispute the decision of a medical practitioner, but the medical practitioner needs to provide a written reply or a written document to prove that the patient is not deemed fit to take the test. In one, a person at a hospital as a patient must not be required to provide unless the medical practitioner in immediate charge of the person's case has been notified of the proposal to require such a specimen to be provided at the hospital. It's difficult to understand that even in the Chinese context, you should have written except that the doctor objects to it. It's like a Japanese synthetic structure right now. It's really difficult to understand that in the Chinese text. You can read it yourself. Members, you can take a look at this sentence too. Do you understand that? There are many double negative structures. Can you make it more succinct, simpler, so that the subject can be underscored? It can be highlighted. Under what circumstances can that be taken? Probably you used English version as the blueprint. Mr. Lee Chen-kung, I just want to echo what you said. I am also worried if you say
As a patient must not be required to provide.
that is in English, a person at a hospital as a patient must not be required to provide. Is it possible that this procedure will be abused? That is, whenever these happen, a person may require to be admitted to the hospital. One may require to go to the hospital in order to delay the test. Do you think this scenario is possible when you write down this in the bill? When someone is sent to the hospital, you are not going to airlift that person to the hospital. So it will have taken some time before one is sent to the hospital. This may be a bug or loophole in your law enforcement. Well, you do not specify under what circumstances when one person becomes a patient, or can you define a hospital patient? Someone has already paid A&E fees, say $100 to $200, and then one can call himself a hospital patient. What is the definition?
嗱，我哋審埋第13條。
Let's adjourn the meeting after we've finished the scrutiny of Clause 13. Say, would a person who has just returned to the hospital for follow-up consultation or has taken medication would be considered as a hospital patient? Well, I assume a hospital patient would be an inpatient, someone who is admitted to hospital. Say, according to Mr. Lee, would someone who has taken medication from a hospital be considered as a patient or a hospital patient? Would the person have to go through certain registration procedure at the hospital to be considered a hospital patient? If the administration does not have an answer now, it's all right. I think there is some problem with the phrasing here. Any final questions from members? Mr. Chen Xiuhong? I think the administration has made reference to Section 39E of Cap 374 as it drafted this provision. Under Cap 374, say someone is caught on the road and it's asked to provide a specimen of breath, or say if someone is found to have committed drink driving or drink boating, that person is asked to provide a specimen, and for some reasons you fail to collect a specimen on the spot and you end up bringing the person to a hospital, and if that person happens to be a hospital patient, then this clause 13 would apply. And under clause 13, the doctor in charge may show up and say that the person is not fit for providing a specimen. I think the phrasing here is similar to that of Section 39E of Cap 374. I think you have to specify under what circumstances this provision would apply in order to make people understand why we have such a provision here. Chairman, I agree that the administration will have to clarify this part. There are 4 subclauses here. Subclause 4 clearly states that this section does not apply to the taking of specimen of blood under Section 11 bracket 4. However, you have to read subsections 1 to 3 all together in order to arrive at this point. Let me look at whether there is anything special in my chairman's brief. Well, there being no further matters, our next meeting will be held on the 22nd of April. If there is any special notice, we will give it to our members.